Good morning, everybody, and welcome back to Coffee with Craig, where we talk about all things Second Amendment advocacy, policy, politics, culture, firearms, you name it. We're talking about it right here on Coffee with Craig. So please take a moment, like and share the program so that your friends can know where you're at right now. Anyway, also, if you haven't already done so, please remember to subscribe and to follow us on Facebook. And remember to hit, in both cases, the notification button so that you can get alerts as soon as we go live. Also, if you haven't already done so, which I know most of you have, but I'm going to encourage you to do it anyway, go to fpcgear.com. That's fpcgear.com. It's a cool place to go to find all sorts of Pro 2A swag, T-shirts, coffee mugs, hoodies, you name it. We've got it there. And, you know, it helps you to show your support for the Second Amendment. But not just show it, but actually do it. Because every dollar that you spend goes right back in the fight for our right to keep and bear arms. So you can support the Second Amendment and you can look good doing it. That's fpcgear.com. Now, many of you may not be aware that there was recently, not too long ago, a hearing in the U.S. Senate dealing with gun control. Specifically dealing with red flag laws or gun violence restraining orders. Now, for those of you who are unaware of what these are, or extremist protection orders, gun violence restraining orders, red flag laws, it's where an individual can go to law enforcement and or the court and to basically tell them that you are a danger to yourself or others, go to a judge, hold a secret hearing where you don't know about it, you don't get to be there, you don't get to defend yourself, and where they deem that you are a danger to yourself or others and you lose your right to keep and bear arms. And then they send law enforcement to your home, to your place of business, wherever they think you might have guns, and confiscate your firearms. And the interesting thing about this is that, well, this particular hearing or this particular measure that they're discussing is being put forward by a Republican, Mr. Lindsey Graham. Now, Mr. Graham is like many Republicans, or several Republicans. I won't say most. I won't even say a huge percentage, but I'll say enough Republicans that for some reason have gotten lost in this idea of what is due process, this idea of what is the Second Amendment, and they've forgotten that your liberty, your civil rights are more important than are more important than a false sense of security. In fact, he was saying during the hearing that, well, if this had happened, you know, Parkland shooting would have never happened if we had had this law in place. The only problem being is that it's already been well documented that there were numerous failures by law enforcement where they could have dealt with that individual and they didn't. There were numerous instances where the school could have dealt with this individual and they didn't. So let's throw all of that. Let's throw all of that aside. Let's ignore all that, and let's just talk about, you know, why these things work. And he talked about that they work. Now, mind you, those who engaged in this, like Senator Dianne Feinstein, who engaged in this discussion about it, you know, all they did was spout rhetoric, and give anecdotal evidence. In other words, offer a specific thing that they thought might not have happened had this law actually been in place. And then when they talked about the success rates, well, they didn't talk about, you know, well, how many people, you know, how many mass shootings they stopped, because, you know, it's kind of hard to prove a negative. But here's what they did. All they talked about was how many firearms were confiscated. That was the measurement. It wasn't, did they stop anybody from doing anything from mass shootings. It was, look at how many guns we confiscated. They didn't talk about how many they had to give back. They didn't talk about how many times they took guns or firearms away or civil rights away from an individual who shouldn't have ever had their rights taken away. Now, one would think that if you wanted that information, you would have invited somebody to come and talk who's actually done research in this area. Somebody who actually knows and understands the issue, like, oh, I don't know, Dr. John Lott. Now, we had staff there in D.C. Our president, Brandon Combs, was there in D.C. trying to get them to have Dr. John Lott, who probably has more knowledge on this issue in his little pinky than all 5 of these witnesses put together, or anybody on the committee put together. But they didn't want to hear from him. Instead, they wanted to hear from folks like Amanda Wilcox. You guys may know Amanda Wilcox. Amanda Wilcox is here in the state of California. You've probably seen her in some of my videos testifying on the issue of banning guns. That's pretty much her thing. And all she really does when she gets up, she doesn't really offer real substantive data or information. She offers anecdotal stories, including her story, which is a tragic one, where her daughter was shot and killed. And that's her motivation for doing all of this. And she brings it up every single time she testifies. So if I seem a little callous, I'm not calloused. I've heard it, and I feel for her as a mother, but it doesn't take the place of substantive data and analysis of that data. Absolutely, positively does not. Even when they brought up a prosecutor from there in the state of Washington, this is an individual who, once again, this is a prosecutor. She should know how many of these things they've done, how many times they've had to give them back, if they've been effective. And you know what? Nope. All she offered was anecdotal evidence. Well, in this particular case, and in this particular case, but didn't really talk about the entire process. Didn't talk about things like due process and the importance of mental health. Because one of the things, by the way, that's very, very interesting about this is they don't really tell you that they don't really discuss the idea of mental health in throughout this whole thing. Now, this is a sheriff, Sheriff Bradshaw. He's actually from the state of Florida, and they've instituted a number of these. And he actually makes a very, very valid point and talks about how important it is that mental health professionals are included in this particular process. Here's a little bit of what he had to say.
Law enforcement must educate and must train its personnel in mental health issues and employ mental health professionals to be part of the risk assessment team.
So one of the things that he pointed out was when they make this analysis, they actually include a mental health professional as a part of the risk assessment team. Most states don't do that. I know California doesn't do that. In fact, in California, there's absolutely, positively no requirement that a mental health professional be included anywhere in that process. Absolutely, positively. There is no requirement, zero requirement whatsoever. By the way, even in the Florida law, which is he represents a county in Florida, even in the Florida law, there is no requirement that a mental health professional be included in the process at all. So when we talk about this being a mental health issue, one would think that you would include mental health professionals. But at no point in the process of any of these pieces of legislation is a mental health professional required. Isn't that interesting? Especially when you go back and you consider the fact that, that was one of the recommendations by the individuals who actually represent healthcare professionals, right? Even they believe that, even though they're like, look, it's not just a mental health thing, but yeah, maybe you should include mental health professionals in the process because, they're the ones that are best equipped to make these decisions. Even a trained law enforcement officer is not a mental health professional. A judge is not a mental health professional. A DA, an assistant district attorney, is not a mental health professional. I'm not trying to put any of them down, but guess what? They're not mental health professionals. They're not. But one of the things I found was interesting, this is the individual, he actually represents National Organization of Mental Health, I think it's experts. But anyway, he had an interesting point regarding, how you address this and the whole due process issue thing and the importance of due process when it comes to dealing with issues like this.
As with any deprivation of personal liberty, it is very important to ensure that subjects of ERPO petitions are afforded due process protections, including notice that a petition has been filed and a hearing scheduled, the right to present evidence in one's own behalf, and the right to periodic reviews to assess whether it is necessary to continue these orders.
See, so even he made it a point to point out, look, these orders where you're having people, where you're sending people to people's homes, and you're not telling them you're coming, and they don't even know that they haven't done anything wrong. They haven't had a chance to defend themselves or have due process. Folks need to have a right, have the ability to be able to defend themselves. They have a right to be able to defend themselves. Now, Mr. Dave Koppel was probably, in my opinion, the best witness because he really had a lot to say and talk about some of the issues regarding the legislation that is being pushed by gun control communities. Now, he was very, because first of all, he started off, he wanted us to understand that, there were people who want to address this, but they want to do it in a way that addresses due process concerns and protects both the individual that's the subject of the order and protects law enforcement who have to go and secure and get these firearms, but also protects individuals who are going and requesting these orders. But I really appreciated that he recognized that not everybody is concerned about rights and liberties, in particular gun control groups.
I support laws to remove firearms from people who pose an extreme risk, not based on some lesser standard as some bills with an extreme risk title, but very different text do. In 2018, the Conference of Chief Justices asked the Uniform Law Commission to draft model legislation. I served on the Uniform Law Commission's study committee on the topic. While the study committee members had very diverse expertise and viewpoints, we were nearly unanimous that the Uniform Law Commission should move forward to draft a fair and thoughtful national model. Unfortunately, the Uniform Law Commission's efforts were shut down by lobbying from gun control organizations. As they frankly stated, they did not want any competitor to their own model, which in my view is dangerous and unbalanced.
Okay, so what we're talking about here is we're talking specifically about the Giffords. We're talking about the Giffords and we're talking about Brady campaign. We're talking about those two particular groups were the ones who really pushed to stop actually putting together responsible legislation, right? Now, he talked about the model that they're offering, which is the ones that you're seeing being offered in state after state after state, being supported by every town. Now, here's one of the first issues that he had utilizing their particular model.
The first problem to address is the frequent misuse of ex parte confiscation orders against innocent people. Any procedure that allows a judge to hear only one side of a case necessarily will produce a very high error rate. Data from the two states with the oldest confiscation laws so illustrate. In Connecticut, confiscation orders may be issued ex parte. Later, the respondent will have an opportunity to tell his or her side of the story in court. In Connecticut, once the respondent does have a chance to tell his or her side of the story, 32% of confiscation orders are overturned. A study in Marion County, Indianapolis, reported similar results. Error rates for newer laws are likely to be even higher. Connecticut requires that a petition be filed by 2 law enforcement officers, and they must have conducted an independent investigation. Indiana likewise requires that petitions be filed by law enforcement. But some states allow petitions to be filed by a very wide variety of people, not just family members, but even including ex-girlfriends and ex-boyfriends or distant cousins, who may have had little or no contact with the individual for years. These states have no requirement for corroboration of any evidence. Indeed, Colorado's House Bill 1177, which will soon become law, legislators removed a requirement that evidence be corroborated.
All right, so let's break this down. So first of all, we're talking about these ex parte hearings. These are hearings where you don't get to be there. You don't even know that the hearing is taking place, right? What they found in these ex parte hearings in the 2 counties where they have some of the strictest requirements, he laid out what's required. The affidavits, the data, the information, the fact that law enforcement has to be included and there has to be corroboration of the evidence. Even in those cases, they found that up to a third of the individuals who had their firearms taken away, guess what? They should have had their firearms taken away. The people who had their rights taken away. should have had their rights taken away. And you're just like, well, but taking away the rights and their guns, the same thing. No, not the same thing. The right to keep and bear arms, the right to own a firearm, that's a right. That's not just taking away your possessions, your private property. That's a right that's taken away. Your right to due process, being able to face your accusers, that's taken away from you, right? The right against unreasonable search and seizure. You've committed no crime. You've threatened nobody. And yet you now are guilty until proven innocent. All of that. You didn't get a chance to face your accuser, none of that. But yet you've lost your rights. And so now, then he points out, you have states where there's absolutely no corroboration required. In fact, not only that, they're expanding the group of people who can request them. Like in the state of California, they keep trying to expand it to include not just family members and law enforcement. They want anybody that you've gone to school, that's taught at a school that you were at 6 months ago. Anybody you work with to be able to put in this request. And oh, by the way, it doesn't require any corroboration. Now, if ones that require the involvement of law enforcement and detailed corroboration, if they're wrong 1/3 of the time, how bad do you think it gets beyond that? How bad do you think it gets for people beyond that? Once you start letting anybody and their mother go in and request these. And by the way, that doesn't even include states like Florida where they do allow anybody and their mother to request them.
Unreliable procedures for ex parte orders ensure that a very large amount of orders will be issued against innocent and peaceable individuals. The problem is aggravated by mandates in some states for automatic, no-notice, surprise confiscation, which may be perpetrated by no-knock raids. One person, Gary J. Willis, a 61-year-old black man, has already been killed by that system. Last November, a month after Maryland's new confiscation law went into effect, police in Ferndale, Maryland showed up at Mr. Willis's house at 5:17 a.m., announcing they had come to take his guns. They talked for a while, then argued, and then the police shot him to death. The victim's niece said that her late uncle likes to speak his mind, but wouldn't hurt anybody. I'm just dumbfounded right now, she continued. They didn't need to do what they did. In the Maryland-style systems, a respondent never receives notice of anything until the police show up to confiscate his or her firearms. This creates an inherently volatile and dangerous situation for law enforcement and the public. The safer approach is to authorize no-notice or no-knock confiscation only when a court has made specific factual findings about why such an approach is needed. Given the dangers imposed by autopilot confiscation, it is no wonder that so many sheriffs around the country are refusing to put their deputies and the public in harm's way to enforce a confiscation order that has a high possibility of being wrong and that can easily be obtained by a spurned former dating partner or a distant relative.
All right, so keep in mind, and this was something that until I heard the hearing, I didn't even realize this because no one ever talked about it. But yeah, the guy in Maryland who was shot, who basically his I believe it was his sister, actually requested a gun violence restraining order against him, and turns out family was saying that it was just some sort of a family spat. Yeah, it turns out he was a black man. And clearly, to Black Lives Matter, this guy's life didn't matter because you didn't see them protesting, because he was basically refusing to succumb to this red flag gun confiscation law. He's like, no, you are not going to take my guns because I have a constitutional right. But once again, this is what happens with these with these no-knock orders, where these ones that are, once again, first you do the ex parte hearing, you don't know about it, they do that, and then they send someone to your house to confiscate your guns. Let me tell you something. They're not coming with a picnic basket. They're not coming bringing flowers and candy. They're coming armed with full tactical gear, ready to take you down if you refuse. And if you don't believe it'll happen, just ask the gentleman who it happened to in Maryland. And you know what? It may have been the first time that this has happened, but I am fully confident that it will not be the last time that it happens. But even then, so let's say all of that happens, right? You go through all of that, and then you finally go to get your day in court. If, according to the law, you get your day in court, you still have prosecutors, you still have law enforcement who are trying to find a way to con you out of exercising your rights.
Government attorneys sometimes discourage people from having counsel at these hearings, even at their own expense. A former Connecticut prosecutor bragged about how he talked respondents out of using lawyers. Colorado has taken steps to prevent such abuse by making court-appointed counsel available to all respondents. But a lawyer can't do much if she is prevented from cross-examining adverse witnesses. Some states eradicate the right of cross-examination. The accuser and witnesses supporting the accuser need never testify in court, where they would be subject to cross-examination and where the judge could observe their demeanor and make a decision about credibility. Instead, persons can simply submit an affidavit. In some states, the petitioner will never be seen by a judge or by opposing counsel. They can make a telephone call at an ex parte hearing and then immunize themselves from cross-examination at a later hearing simply by filing an affidavit. States that thwart cross-examination, promote unnecessary no-notice, no-knock raids, may have or leave innocent victims without a civil remedy for false or malicious petitions, or which deny other core elements of due process, should not be rewarded with federal funding.
So see, even if you get your day in court, there's no guarantee that you're going to get a chance to actually face your accuser. You may not. You may go to court. You may not even know exactly what they said or how they said. The judge may not even, in some cases, in the ex parte hearing, may not have even talked to the person making the accusations. May not have even seen them or talked to them. They may have just filed some piece of paper or made a phone call. And then on top of it, you literally have law enforcement and you have prosecutors that are discouraging people from exercising their right to counsel. And in some cases, it doesn't matter if they do because, hey, you're not going to be able to question anybody. You're not going to have anybody to whom you can cross-examine. But this is due process. This is the sort of due process that Lindsey Graham and Dianne Feinstein are interested in. This is what they call due process. Look, here's the thing, and this is the Sheriff Bradford made this very interesting point. And it was one that even though he believes in these extreme risk protection orders, it is the one point that is the most important. And that is that it's not about the tool. It's about the individuals. We're not trying to stop. We're not trying to take people's guns. It's not about taking people's guns, although that's exactly what they're focused on. That's all they're focused on. You would think that they would be thinking about how we can keep these things from happening.
Our goal here is to identify people that have the potentiality to perform these violent acts. Because it could be a car, it could be a rock, it could be a knife, it could be a pressure cooker. So sometimes it's not the instrument, it's the hands of who you put this instrument in.
And yet and still, all they are talking about is how we take the instrument, in this case, the firearm, away. That's what they're going to be talking about. So overall, this hearing, no legislation was actually voted on or anything like that. This was largely a hearing for people to be able to get information and put forth information. And I think you just heard the best of the information that was provided and made available. The fact is, I think all of us don't want people who are a danger to themselves or others to have firearms. But I think the most important thing for us is that we not give up our liberty for a false sense of security. We not give up our due process rights. We not give up our right to keep and bear arms. We not give up our right against unreasonable search and seizure. That we are innocent until proven guilty. These are all things that need to be respected. I don't care if you're a Republican or you're a Democrat. If you are proposing a law that violates my civil rights so that you can get a poll bump, I'm sorry. My opinion, you should pay the price. And that price is to have your ass voted out of office. Anyway, folks, thank you so much for tuning in. That's going to be it for today's Coffee with Craig. We very much appreciate you guys tuning in. We appreciate you liking and sharing this program, telling your friends about the Firearms Policy Coalition. We are the home in the fight for civil rights. Got to use them or you're going to lose them. You guys take care.
If you like our videos, follow, subscribe, like, and share.